Hamis Kiggundu, in filing this case, raised 7 grounds citing that Justices of Court of Appeal erred in land fact in delivering their judgment in the case he had filed against DTB Uganda and DTB Kenya. Justices in this matter include Chief Justice Alfonso Munyidolo, Faith Monda, Pase Knight Tuhaise, Justice Stephen Musota, and Justice Mike Chibita. Justices said there was no law brought or cited to the attention of this court forbidding the creation of the impunged syndicated agents relationship between DTB Uganda and Kenya.
This is because the first respondent is responsible for the disbursements of the funds from the second respondent to the appellants, holds the mortgaged loan securities in trust for the second respondent, and follows up on the servicing of the loan by the appellants for remittance to the second respondent. Furthermore, it's worthy of note that no law was cited or brought to the attention of this court which forbids the creation of the impugned syndicated agency relationship entered into by the first and second respondents. Similarly, no law was brought to this court's attention that forbids foreign financial institutions from extending credit facilities to any financial institution or person in Uganda. If anything, in furtherance of international trade and investment, financial institutions the world over are known to engage in global financial business transactions by dealing with or through financial institutions based in other jurisdictions. Similarly, no law was brought to this court's attention that forbids foreign financial institutions from extending credit facilities to any financial institution or person in Uganda. Financial institutions the world over are known to engage in global financial business transactions by dealing with or through financial institutions based in other jurisdictions. Accordingly, then, the Court of Appeal ought to have addressed and determined the issues of illegality of the credit facilities extended to the second respondent to the appellants therein, and then refer the case back to the trial court for determination of the issues of facts.
Court also ordered that such syndicated transactions, which were done by DTB Uganda to Hamis Kiggundu, are not governed by the laws of Financial Institute Acts in Uganda.
As is discernible from the analysis above, the rights and roles of the agent appointed in the agency relationship provided for under the Financial Institutions Act of 2004 as amended, and the 2017 regulations made thereunder differ markedly from the ones conferred on the agent appointed under the syndicated relationship. The duties of the agent in the syndicated relationship are much wider than that conferred on the agent provided for under the Act and regulations made thereunder. Most notably, a financial institution in the syndicated credit facility arrangement, which is appointed an agent of the other creditors in the syndicate, remains at par with them. I can't see how this arrangement and the transactions that were carried out pursuant thereto could be construed to mean that the second respondent carried out financial institution business in Uganda within the meaning ascribed to the phrase financial institution business by the Financial Institutions Act of 2004 as amended, and the Financial Institutions Agent Banking Regulations 2017 made thereunder. In the case of Uganda, such international financial business transactions are certainly neither governed by the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations of 2017. The syndicated credit facility executed between the second respondent and the first appellant, with the first respondent as agent of the second respondent, is lawful, and neither the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations apply to them. Number 3, accordingly, the claim impugning the legality of the credit facility contracts between the parties hereto is disallowed.
On the grounds that Justices Eladin learned facts when they abandoned the grounds of appeal by introducing new grounds, Supreme Court ruled otherwise.
These issues, save for the one on amendment of the plaint, flowed from ground 9 and 11 of the appeal. I am unable to fault the Court of Appeal for, in the exercise of its duty to re-evaluate proceedings of the trial court, noting glaring errors in the procedure adopted by the trial judge, the determination of which it deemed might have a bearing on the decisions of the trial judge. In the circumstances, the Court of Appeal was right in raising of its volition issues which merited consideration, albeit that they had not arisen from any of the grounds of appeal. The court identified such issues as the amendment of the plaint, the entering of judgment under Order 6, Rule 30 of the Civil Procedure Rules, and the legal basis for the orders granted by the trial judge, all done without conducting any hearing to determine inter alia whether the parties were in pari delicto and whether a cause of action can be founded on an illegality. In this, the appellant suffered no injustice whatsoever. Where the determination of these issues disposes of the appeal, there would be no need to proceed with any other ground of or issue arising from the appeal. In the premise, I find that ground 2 of the appeal, in which the appellants fault the Court of Appeal for raising issues outside the grounds in the Memorandum of Appeal for determination, devoid of merit, hence it fails.
Therefore, court ordered a retrial and also ordered Hamis Kiggundu to pay costs of 50% for both Court of Appeal and Supreme Court.
The issue of illegality having been resolved in this appeal, High Court Civil Suit number 43 of 2020, between the parties hereto, which was the genesis of this appeal, which was the genesis of the appeal to the Court of Appeal and ultimately to this court, is remitted back to the High Court for trial before another judge, basing only on issues of fact arising from the pleadings. The respondents are awarded 50% of the costs in this court and in the Court of Appeal. Since the other members of the quorum are in full agreement with the judgment and orders, I have proposed above. Judgment and orders are accordingly hereby given in the terms stated out herein, dated this day of June 2023, Alphonse Chigamoy Owinyidolo, Chief Justice, signed. Then there are 4 concurring judgments, as I had stated earlier, of Justice Faith Monda, Justice Passet Haise, who is myself, Justice Mike Chibita, and Justice Stephen Musota. They are all duly signed. And this judgment, I will repeat, will be sent to you. Soft copies of this judgment will be sent to you immediately. Thank you very much.
Hamis Kiggundu's lawyer failed to arrest the judgment as court overruled their prayers.
We have received the judgment, and the Supreme Court, in its own wisdom, has directed that we should not talk about the issues of illegality, even in the High Court, which we think is wrong, because as you have seen, we had applied to this same court to adduce evidence of illegality. But the Supreme Court has refused and has said, don't talk about that. Go back to the High Court and talk about matters of facts, whether there was a loan or what. And we are not happy with the decision, but we accept it. We shall go back to the lower court and argue. In fact, the Supreme Court has confirmed that the transaction was illegal because it is not supported by law. But they say, since it is a syndicated loan, which the same court has not quoted any law supporting it, that it should go ahead. So we have no problem. We shall go and argue our case. We are just beginning.
The appellant Hamis Kiggundu this time round didn't appear in court, though his supporters expressed dissatisfaction.
Seriously, as Ugandans, as you're seeing, the people here, they're not happy at all. Things are not good. DTB Bank is not being fair. We are advocating for justice. We would want Mr. President to intervene. This is our petition, and Ugandans, the members have signed upon it. So we require you to please come have a way in this, and we find justice. Yes, this is the petition. They can go through it. On behalf of the Ugandans, this case now is beyond Hamis Kiggundu. It's now concerning all Ugandans. And these are the people that have signed upon it. We would require Mr. President to come have a way into this. Thank you. We are seeing courts referring Mr. Hamis Kiggundu, go to this court, go to the other court, which is not fair. We all know it was fraudulently done by DTB Bank to deduct money on his account, which we all know the man was saving with it. And it is not fair at all. If it were you, trust me, it would really hurt you if you save your money and then the next day don't find your money on the account. I wouldn't find that fair as a Ugandan. So I would request the national chairman to please come away into this, and we see how best we can fight DTB Bank.
Tukoze petition eno katuwandika president w'eggwanga ayingire mu nsonga zino kuba tulabawo obutali bwenkanya. Antone General wa Uganda kiri wakiwanuka ne mukodde wa president obayingira mu nsonga zino kitegeeza wajja kubeerawo obukumpanya kuba bebawolereza DTB Bank. Kati obanga omuntu alina obuyinza bwe butyo Antone General wa Uganda kiri wakiwanuka oli mukodde wa president olaba enkimo zokusala gw'ekibira tesobola kusala gwa kibira bebawolereza DTB Bank kitegeeza tetusuubirayo bwenkanya mu kooti olw'ensonga abantu abawolereza DTB Bank bayina obuyinza bungi mu gavumenti eno oli mukoddomi omulala Antone General wa Uganda tosuubirayo bwenkanya mu kooti kyova tuvuddeyo tugamba president tumuwandikidde yingira mu nsonga zino ng'obudde bukyali.
DTB Uganda and DTB Kenya were represented by lawyer Edward Karugire. Hamis Kiggundu claims that DTB Kenya illegally withdrew 120 billion from his account without his consent in form of paying a loan he had borrowed from DTB Uganda. Deborah Namamonde, UBC News.